Good day, Crime Talk aficionados. It is Saturday, October 15th, 2022. Let's go ahead and roll. Good day, Crime Talk aficionados. It is Saturday, October 15th, 2022. It is our weekly recap of all the top stories located in one convenient place for you here on the weekend. Thanks for watching. We'll see you next time on Crime Talk. Next on the docket, Lori Vallow, Valo-Daybell. The prosecution doesn't want to go to trial either in this case. The prosecution filed their response to the motion to continue filed by Valo-Daybell. Not surprisingly, the prosecution did not object. In fact, they joined. In fact, they gave more reasons for the judge to continue the Valo-Daybell trial. And besides, the prosecution hasn't objected to a single continuance requested throughout these proceedings, so I'm not sure why they would start by now by saying that they were ready to go to trial. The reasons for not opposing the continuance are: first, the state would request both matters be stayed pending a status conference to be scheduled in January based upon the following. The court has determined that the defendants are properly joined for trial. A stay is necessary for defendant Vallow. Defendant Daybell has previously waived speedy trial and is now requesting a continuance. Defendant Daybell has requested his case be continued with a new trial date to be selected in January. The state believes if both matters are temporarily stayed, it will avoid relitigation of the same issue. The state would request we wait to select a new trial date until both defendants are in a position to have input in the selection of the trial date. The state would agree with the defendant Daybell's position. We wait to select a new trial date in January. And the state would suggest the court consider setting a trial date to begin in September of 2023 to allow Madison and Fremont counties to split the costs involved in the trial and a change of venue across the 2 fiscal years. The state believes the court can find good cause to continue the trial date for both defendants, given the complicated statutory issues with defendant Vallow. The joinder of these defendants is in a single indictment, the court having vacated the trial date in the co-defendant's case and defendant Daybell's previous waiver of speedy trial, the current request by the defense for continuance, and the complexity and the costs involved in moving the trial to Ada County. Well, let me summarize what that means. Judge, we don't want to do this twice because it's expensive. Daybell has previously waived speedy trial, so don't make us do this twice. It's expensive. Let's wait until Lori Vallow is competent so we don't have to do this trial twice because it's expensive. Set this in September so that we can split the cost between the fiscal budgets because this is really expensive. So in summary, do what we tell you to do because this case is really expensive. Ladies and gentlemen, justice is expensive. I am surprised that the prosecution just simply doesn't say, we are ready. We will do this trial any place, anytime. You tell us where, Judge. We'll have our witnesses, we'll have our evidence, and we will be ready to go. But instead, they continue to delay as well. It's always about the money, ladies and gentlemen. It's always about the money. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. I am just as disappointed with these circumstances as you are, but we've got some news. All right, so before we go ahead and get to that story, let's go ahead and open the record for October 13th of 2022. So we do know that a motions hearing was held for Valo-Daybell on his matter today. Obviously, Lori Vallow's matters are all stayed because, well, competency issues have been addressed again. Now, Lori Vallow's attorneys were there to see what was going to take place, but there were several major issues addressed. First, the parties addressed the motion to continue filed by Chad Daybell. The government, as we've stated and we've talked about in great length in previous videos, doesn't object for all the reasons outlined in their previous motions. And oh, by the way, did I mention because it's really expensive? Judge Boyce did not issue a ruling from the bench and advised that he would take the matter under advisement and will issue a written opinion. The court briefly addressed the severance issues, and the court made no decision. And what is worth noting is that there's reports that not only in the motion for severance that we have talked about, where Chad Daybell, through his attorney, referred to Lori Valo-Daybell as Miss Valo, which I would note we have done from the beginning, well, just because it kept it cleaner. And I also didn't think that the relationship was going to last. And Chad is basically saying, Lori, it's not you, it's me, but we're breaking up. And why are they breaking up? Well, just once again to briefly recap from the motion for severance, based on the allegations in this case, one of the plainly available defenses would be to demonstrate that Ms. Valo and her brother, Alex Cox, were responsible for the alleged crime, and they acted as part of their own conspiracy and did not involve Mr. Daybell. What's the best way to get that severance? Well, you need to distance yourself. What's the best defense? Say, oh, she did it. Been saying that all along. Well, we'll see. The court didn't issue a ruling just yet, but I think that Chad Daybell has made enough of a record at this point for a severance to be granted. But hey, who knows what's going on in Idaho? We'll have to wait and see. And then the court ultimately denied the motion for a bill of particulars, which Mr. Pryor asked for more information regarding the charging documents, unclear under which theory of prosecution the prosecution was going forward. And the judge denied that and said, you have all you need to know. Mr. Pryor referred to Lori Valo as Miss Valo, not Miss Valo-Daybell, as she prefers to be called, and as, well, they've referred to her in the past. Now, oh yes, Lori Hellis, remember her? That's right, our hero. She had some motions before the court, which was basically to say, Judge, you need to unseal all those documents because you didn't do it correctly. And I have communicated briefly with Lori Hellis. She was driving, so we didn't have a chance to get into great detail. But as I understand it, the court is going to take the matter under advisement. And I also understand that the court was in somewhat of an awkward position when Lori Hellis pointed out that the court's most recent orders regarding sealing of documents complied with the law. And then the court somewhat had to acknowledge that, well, now you have to go back and decide what you're going to do with the previously sealed items where the law was not filed. So, like I said, Lori indicated to me that she was driving back to Boise, and I hope to have her on and at least talk with her to get all of the scoop straight from her directly. I still think there's a little bit of hope that the judge will realize the errors of his ways, but I think he will find a way to keep everything sealed so that, well, we don't get to see anything what's going on, which is just wrong. Darrell Brooks, remember that guy? Yeah, the one that's on trial? Well, at least he's taking advice from someone, I hope. That's right, Darrell Brooks, the man charged with murdering 6 people by ramming his SUV through a Christmas parade, apologized in court this morning for lashing out during his trial. The self-professed sovereign citizen has been representing himself since firing his public defenders just a few days before his jury selection was to begin. Mr. Brooks said in court, I would like to issue the court an apology for my actions last week during the trial. I want the court to understand it's very emotional right now, not only for just the whole situation of the trial. The families here have to go through everything that's going to be involved with this trial, but also my family and myself. It's very emotional, but not to excuse my actions. I should have carried myself with better respect. I wasn't raised that way. I owe you, Your Honor, and the court an apology, and I want to stand up as a man and tell the whole court. He stood up and, Your Honor, apologized to the bailiffs that I apologize for my actions. He said, like I said, that's not how I was raised. I come from a Christian background. My mother did not raise me that way. She did not raise me to act out of frustration, irritation, and anger. I just want everybody to know that I apologize for my actions, Brook continued. And he says he's going to do his best, whatever happens, to conduct himself with respect and respect to the court. And he said he wanted the court to know that the prosecution, judges, and bailiff, clerks, reporters, everybody in the audience, everybody here, he wanted everybody to know that. The judge said that she appreciated that. Understandably so. This is an emotional experience. I think everyone involved, she said, and I appreciate that you, upon reflection, I have realized that courtesy and decorum are an important part of the court proceeding. I agree. And I'm glad Mr. Brooks apologized and hopefully will behave better. He should have never have fired his attorneys. But hey, we'll give him the presumption of innocence, but I think at the end of the day, he will more than likely be convicted of all charges and a lengthy sentence will be imposed. But at least he's going to go down with some dignity. Mr. Brooks is accused of obviously driving through the Christmas parade and killing many individuals where he was allegedly fleeing after punching his girlfriend and harassing her. Apparently, he's got some impulse control issues. Maybe some anger issues when he gets frustrated and upset. Well, before firing his attorneys last week and acting as his own lawyer, Brooks walked back his plea of not guilty by reason of insanity. He is saving his opening statement for after the prosecution rests their case. First, representing yourself is the dumbest thing you can do. I know someone will always say that there was this one case where someone represented themselves and they won. Yes, and that's rare. And it's few and far between, and maybe it's like a traffic case or something along those lines. Remember, he who represents himself has a fool for a client. Now, this was a pretty blatant attempt to delay the trial by firing his public defenders, and it was desperate. Now, at least he gets to sit in the same courtroom and hasn't been removed for disturbing the proceedings. I would tell him you are not helping yourself by being disruptive in court. And apparently, I don't know, maybe his mom spoke with him. I don't know if she's around at all, but at least his mother, assuming it's his mother, somebody told him, this is not the way your mother raised you. Don't act like this in public. Just wish he had got that word a little earlier before he ran over multiple people at the parade. Next, evil gets no reprieve. 7 years after his racist mass shooting inside a historic black church, which killed 9 people and terrorized a nation, convicted murderer Dylann Roof lost his bid for the Supreme Court to review his death penalty case. The justices rejected his petition without any noted dissent or explanation. Now, Roof opened fire of a group of black worshipers taking part in a Bible study inside the Emmanuel African Methodist Episcopal Church on June 17th of 2015, ultimately resulting in 9 deaths. A federal jury in South Carolina found Roof guilty of all 33 of the alleged charges that he was charged with, and later the following year sentenced him to death. Now, Roof later pled guilty in his related state prosecution in exchange for a life sentence and no chance of an appeal. In seeking to avoid the capital punishment in the federal case, though, Roof's defense attorneys wanted to present evidence depicting him as an autistic and psychotic individual, but Roof refused that option to avoid discrediting what he viewed as the political motivations for his act, because he wanted to provoke a race war. Real class act this guy is. Anyway, the mass murderer also expressed no remorse for the people that he killed. Now, for Roof's federal public defenders, that sequence of events raised an unresolved question as to who gets the final say over what mitigating evidence is presented in the death penalty case, the defendant or his lawyers. So Roof fired his lawyers and stood alone against the government at his sentencing hearing. He presented no evidence or intelligible argument for his own life after the district court told him that the counsel could introduce evidence depicting him as mentally ill over his objection. His attorneys wrote in their petition for a writ of certiorari for review by the Supreme Court, quote, "But while that is the law in the Fourth Circuit and a handful of other jurisdictions, the vast majority of state and federal courts hold otherwise, leaving this deeply personal choice to a defendant. Had Roof been tried in any one of those majority jurisdictions, he would not have been forced to self-represent himself at his capital trial to block his own attorneys from presenting evidence that he abhorred, end quote. Though his crime was undeniably horrible and the government's case in aggravation substantial, they argued that Roof had a meaningful non-mental health mitigation defense that the jurors should have heard. Well, this goes back to August of 2021 when the Fourth Circuit Court of Appeals rejected that view, writing that Roof deserved the punishment available. Quote, no cold record or careful parsing of statutes and precedent can capture the full horror of what Roof did. The court's ruling stated, his crimes qualify him for the harshest penalty that a just society can impose. Now, just by way of background, just so everybody understands the horrific nature of this crimes, is that the Emmanuel parishioners welcomed Mr. Roof into their congregation for a Bible study and offered him literature for the day's discussion. The group prayed for 45 minutes, and as the session ended, Roof then pulled out a semi-automatic handgun that he had concealed in a bag that also carried 8 magazines loaded with 11 rounds each. Now, 28 years old, Roof awaits his execution inside the maximum security prison in Terre Haute, Indiana. Next on the docket, the fallout from Nikolas Cruz. Will there be a do-over? I don't think so, but let's see what's being said. First, prosecutors are demanding an investigation into an allegation a juror was threatened in deliberations whether to sentence Nikolas Cruz to death. A juror called the Broward State Attorney's Office immediately after the verdict was announced that Cruz, who is now 24, would be given life in prison without parole. This alleged juror informed staff that she received what she perceived to be a threat from a fellow juror while in the jury room. A second female juror wrote a letter to the judge that others were extremely unhappy with her decision to give Cruz life in prison rather than the death penalty. Now, lead prosecutor in the case, Michael Satz, is now calling for law enforcement to speak to the juror as they believe a crime may have been committed. Most jurors wanted Cruz to receive the death penalty for the 17 murders he committed in the mass shooting at the Marjorie Stoneman Douglas High School on Valentine's Day back in 2018. Now, Florida law requires the death penalty recommendation to be unanimous to impose the fatal sentence, and the jurors did not all agree in the case of Cruz, sparking emotional outbursts from relatives of the victims. Now, prosecutors are asking for the investigation under a criminal procedure which allows for it in cases where a verdict may be subject to challenge. However, it's very unlikely that the allegations made by the juror of misconduct will change the outcome of the trial, as it was in Cruz's favor. Now, threatening a juror under Florida law is a third-degree felony punishable by up to 5 years in prison, with a hearing scheduled for Friday to discuss this particular motions. Now, it is unclear if the threatened juror voted for life or death, but a juror wrote a letter to the judge that others were extremely unhappy with her decision. The juror, one of the 5 women on the panel, who was the sole juror who maintained her decision that Cruz should be sentenced to life in prison. In a letter submitted to the judge, the juror recalled heated debates with the jury over the fate of Mr. Cruz. She claimed that despite rumors that they had already made up their mind prior to the trial, that they remained fair and unbiased in making their allegedly unpopular decision. Now, the deliberations were very tense, and some jurors became extremely unhappy once the juror said that she was going to vote for life. Her note to the judge stated that she was truthful when she was qualified as a juror. Now, remember, for you to be qualified as a death-qualified juror, you have to be able to say, I am willing to follow the law and impose the death sentence if I believe that the factors have been met. If you go in saying, I don't believe in the death penalty, or that I would never impose a death sentence, well, that juror then would have not been truthful if that were to come out. But if they said all the right things, very unlikely that anything would in fact be changed. So, any chance of a do-over for the sentencing phase for Nikolas Cruz? Highly unlikely. As the law stands in Florida, it just takes one juror to say life. Normally, as you may recall, that we've talked about many times, the factual stage of the trial of guilt or not guilty, the jurors must agree unanimously for guilt or not guilty. So a little different when it comes to the sentencing phase there.